Okay, so it's just about 12:30 now, and I like to welcome people as they are joining still to this webinar. Just a few housekeeping rules, not really rules, but general housekeeping stuff. The first is I just want to just say a word or two about our firm. We have some exciting news, and that is that as of yesterday, we have 3 new lawyers that have joined us in the Kitchener-Waterloo office. They were from a prior local firm. They come with a lot of experience, and we're very excited to have them here, and you'll be hearing a lot more about them as we get going. My name is Dan Strickberger. I am a founding partner at the law firm. I have had the pleasure to work with most of you. I do a lot of work dealing on the first party claim side of things, a lot of priority and loss transfer work on the accident benefits side. I deal with a lot of auto coverage work and have written a book on that subject as well, which is one of the best sellers on Oprah's list. And also, I am just, I wanted to take this moment to just sort of thank you all for coming and listening during this lunch hour. So let's jump into the presentation that I've got here going. So I've named it More Than Just a Feeling, turning information into evidence. And the reason is, and this presentation was born out of things I've seen, I guess, for lack of a better way of saying it, when I'm file handling and just stories I've heard in the industry and all that. But sort of there seems to be sometimes a disconnect between gathering information on a claim and then actually being able to use that information when it gets to a hearing. And so I'll show you pretty much what I'm talking about here. So when I'm talking about information, and for those of you who have trouble saying it, I know I stutter trying to say it sometimes. There's the description how to pronounce information up top. But basically what we're talking about is anything, any knowledge communicated about any fact or circumstance. Information comes from everywhere, and I'll get into that shortly. But that's basically when we're reviewing files, we're pretty much looking at information that has been gathered on the file. And it also helps us assess what kind of information we need to get going after that. When we're dealing with evidence, evidence is, of course, information can be evidence, can go towards proving or disproving a fact. But for the purpose of this presentation, what I'm really focusing on is sort of the legal term of evidence. And there's a description at the bottom here. It's the data information presented to a court in proof of facts in issue. And that comes from many different sources as well. And as I'll get into shortly, there's a difference between information and evidence. And that's because when some of the themes that I'm going to be talking about, if you're a claims adjuster or manager, whatever role you play at the insurance company, when you're handling a claim, you need information to be able to handle and respond and adjust to a claim. And this information comes from many different kinds of sources in a claim, such as applications or proof of loss, or simply just speaking with your insured about the claim. So this applies equally to first party, third party claims, and so on. Now, when there's a dispute, however, lawyers can't really just deal with the information. The information has to turn into evidence to prove a case at a hearing. Now, to get into that, and just to show you an example, you can't really adjust a claim without information. Obviously, you got to know what the file's about. But you also can't go to a hearing without evidence. And gathered information does not necessarily become evidence. And again, I'm talking from a legal standpoint. Information doesn't win hearings, it's actually evidence does. And although this seems a bit confusing, perhaps, there's nothing wrong with calling information evidence, and we see that all the time. But from a legal perspective, you can't just file all sorts of information that you may have collected on a file and actually have it admitted as evidence. So unless you're able to take the information that you've gathered and turn it into evidence, you're not going to win your hearing, right? So I'll just get into this a bit more. Now, when you're talking about a type of hearing, on the left side here, I've got different kinds of hearings that we see. So we have trials and civil litigation. You've got arbitrations. It could be public or private. And then in the accident benefit world, we have these administrative tribunals, right? These are what we call hearings at first instance. And when these hearings start, there are typically, and I'm looking again through the lens of the hearing adjudicator or the judge or the trier of fact, basically, there are usually no facts that have been admitted into evidence yet. Now, there might be some depending on the case and the style of the proceeding, but for the most part, if you have any information and you want to get it into the hearing, it has to be admitted into evidence at the hearing. And then the appeals, on the other hand, those are hearings at second instance, for lack of a better way of saying it. Those appeals are decided based on facts that have already been found below. And the findings below, meaning at the first instance hearings, were based on evidence that was admitted into those hearings, which form part of the record of the hearing below. So if you are an appeal officer, an appeal judge, whoever the case may be, you're not making decisions based on new facts. You're not making decisions based on new information, subject to some exceptions, of course, about filing fresh evidence, it's called. But you're really making decisions based on what was already admitted and found as facts below, which is even more important because if you're unsuccessful at an appeal, you want to make sure at least that you got all the facts in so that you can have a better chance at convincing the appellate court that there were some issues below. Now, when we're talking about information, again, there are many sources of information. Of course, you've got your witnesses, you have documents, for example, that you found in a police report. You could do your own research online, and you can, these days, if it's a property loss or motor vehicle accident or those kinds of losses where the location matters, you could go onto Google Maps and really literally use Street View, and then you could just basically what I call walking up to the area of the loss. And often you're also using feelings, right? You may have certain hunches, you might have certain, smell tests and things don't necessarily seem right. So you'll be looking there as well. Now, just sort of looking at it, you also have, in today's day and age, video. It could be surveillance video, could be closed circuit camera video of the accident. And now we're seeing a lot of times in motor vehicle, we're seeing dash cam footage, which, if a picture says 1,000 words, video from a dash cam showing how the accident happened could be basically, a slam dunk, right? A million words or a bazillion amount of words. So it's this kind of information that you want to get at. And of course, you have your social media. These days, you find tons of stuff on that. So these are things as you're adjusting a file that you're sort of collecting and trying to figure out exactly what happened, and maybe trying to figure out if the loss is covered by the policy, or if you're trying to determine fault, or if you're trying to basically determine if there's certain, in the case of statutory accident benefits, entitlement to different kinds of benefits, so seeking medical records and the like. Now, when we're talking about evidence now, we're talking again about how to get the information into court, right, or into a tribunal. And so looking at the sources of evidence, most of the time, the evidence that we want to get in, at least the best kind of evidence, is the sworn evidence. And so at trial, you'll have people being called in as witnesses, and they give an oath and they testify. And because they've given an oath, there's sort of an assumption that at the very least they're going to be telling the truth. Of course, it doesn't always happen that way. When we're dealing more on the administrative tribunal sides, we see a lot of examinations under oath. We see a lot of examinations for discovery and other kinds of sworn evidence that is very useful because it's already been sworn. And I'll sort of touch on that a bit after. Other sources of evidence that we rely on all the time are documents. They could be paper, electronic, emails, photos, memos, text messages, and notes, etc. This is all information, of course, but it could also be used as evidence if it passes the admissibility test, which I'll touch on shortly. And it also, we see in litigation requests for admit. There's no such creature, at least in the arbitration world, although several times we actually do ask people to request to admit certain things. And of course, if they fail to respond to that, then that could be a deemed admission. But it just basically, any fact that is admitted doesn't need to be proved because there's no issue as to the truth of its content. Now, when you're dealing on the adjusting side, can't really think of any rules with respect to evidence. I mean, you obviously, you're looking for credible evidence, you're looking for reliable evidence, information, evidence, reliable, credible, useful, and all that. But you don't really have rules with respect to what it is that you may find or how you're going to find it, or perhaps decisions that you'll make based on what you've collected. On the other hand, when we're in a tribunal setting, or a court setting, or whatever the case might be at an actual hearing, the law dictates what can be entered into evidence at a hearing. And so in Canada, sort of federally speaking, we have the Canada Evidence Act, which we don't really deal with that often because it really deals with usually criminal issues. The one that we do, that's binding on civil litigation is the Ontario Evidence Act. So that comes into play a lot, especially at trial. And there's also the common law. And there are many cases spanning centuries dealing with rules about evidence and all that. Again, none of these apply when your claim's adjusting, but if you want to take to a hearing, it's got to fit within these rules, otherwise the evidence may not get accepted. Now on the tribunal side, both either at the LAT or in a private arbitration under the Arbitration Act, the evidence rules are very relaxed. And just to give you an example, the Arbitration Act refers, basically, when it comes to evidence, it sources the rules of evidence from the Statutory Power Procedures Act. Same with the LAT. So basically, and it says when evidence is admissible at a hearing, is that subject to some exceptions. Obviously, a tribunal may admit as evidence at a hearing. And this is sort of what I highlighted because this would never work in a trial, but whether or not given or proven under oath or affirmation or admissible as evidence in a court. And that could be any oral testimony or any document or other thing. Now, so you could imagine how relaxed that is, because when you're collecting certain documents and all that, the tribunal may admit them, even though there hasn't been any oath taking or affirmation as to the truth of their contents. The other part there is that it's got to be relevant. And this concept of relevance comes up all the time because you may be collecting tons of information about a claim, which may seem relevant with respect to that particular claim. But at the end of the day, trier of fact might look at it and say, well, this isn't relevant, so I'm not even going to admit it into evidence. So we have the information with us and we'd love to get it in so that they'll consider it, but we can't even use it because it's been deemed to be not relevant, which is always a very scary position to be in if you're actually trying to rely on it. So when your claims adjusting, and this is something that this is sort of the genesis of where this presentation came from. So you can make decisions without evidence, again, the legally speaking evidence, because you don't have rules of evidence when your claims adjusting, right? So you can collect whatever information it is and basically make decisions on that, even if perhaps it wasn't reliable, or even if perhaps it's, it may not even be credible. Now, that's not obviously the best kind of information that you want to be making decisions on, but nothing's really stopping you from doing that, at least from a legal standpoint. It doesn't have to be, you can make decisions on information that may not be admissible in a court or tribunal. So that's pretty important with respect to giving you some freedom when it comes to collecting information and using it for your files. You will collect information about the claim, and this is important because when you're trying to handle a certain claim, and I use the priority dispute as an example when you're dealing with accident benefits, you've got 90 days at the beginning when you get a completed OCF1. You have 90 days to investigate the claim and to determine if there's another insurer out there that you want to send a priority notice to. Now, right off the cuff, since 2010, at least, since they made some revisions to the priority regulation, we've seen insurers jumping straight for the examination under oath. So basically, you get a completed application, then you want to set up an examination under oath. And what happens inevitably in many cases is that you just don't get that examination under oath within your 90 days because you can't reach the claimant, or the claimant refuses to attend, or they don't attend at certain places, or maybe the scheduling for the examination under oath happened a bit too late. And so there's panic. Now, I've always said when you're dealing with your 90-day notice, you don't need to have an examination under oath, right? And what I'm saying is you still want to get the information that you would get at an examination under oath, but it doesn't have to be sworn evidence, because really what you're looking for during this stage is information. You need to get information about the claim. You need to find out whether the person has other insurance accessible and who they may live with and whether they're married or not. Whatever that case is, you just need information to identify another insurer. It doesn't have to come in the form of sworn testimony. Now, of course, the claimant may lie when they're giving you that information, but that's an issue we could deal with later, right? You're just trying to get that information now. So when you're collecting that information, it doesn't have to come in the form of sworn evidence. Now, as I'll explain soon, when you're at a hearing and a lawyer's trying to prove their case, it's better to have the evidence come in a sworn examination under oath, for example, especially if you're not calling that claimant or whoever the witness is to come testify. But that's information that we could get later as well, which I'll sort of touch on. So when you're getting all this information, you're basically assessing what you've collected, and then you're going to make decisions based on the collected information that you've received. And you can make decisions, again, based on inferences. It could be based on inconclusive information, it could be based on a smell test, whatever the case is, you'll make those decisions. And again, I'm not suggesting that you shouldn't go after better information to make your decisions, but I'm saying at the end of the day, if you decide that you're going to deny a claim or whatever the case is, it could be done based on these other factors below. Now, when we're dealing with a hearing, all evidence relevant to a fact and issue is admissible. This is like sort of the basic rule of evidence. So it's admissible, but it has to be relevant, and there could be a legal reason for excluding that evidence. So the party trying to prove their case, they've got to put forward reliable evidence. And the information that they're producing, it's got to be relevant and material to prove a fact that is in issue in the hearing. So again, this concept of relevancy is huge. It's got to be, it's got to advance the fact finding in the court. It just can't be based on random facts and things which have nothing to do with the hearing at all, or with the issues. And the evidence also cannot be subject to any exclusions, such as hearsay, which I'll touch on very shortly. And also, it's got to be probative. It can't, it's got to move along, again, the fact finding, the dealing with the issues. It can't be prejudicial. And this is an issue. The prejudicial stuff comes up a lot with juries, because juries have a very hard time disregarding the evidence that they've heard, of course, right? And if even with proper instructions from a court to tell a jury, well, you can't really consider this, you can't really consider that, if it's within the evidence pool that the jury is going to look at, and realistically, there's no way that a jury is not going to consider it, then it may become prejudicial. Now, once all the evidence is in and the parties are basically, presented their case, so the trier of fact weighs the admissible evidence and makes findings of fact based on that. So when you're reading a decision and the trier of fact is going through the facts, they're basically going through the fact finding that they have made based on all the evidence at the hearing. And then once all the facts are found for a particular issue, the trier applies the law to the found facts, and then there's a decision that's rendered. So this is, again, very different than the claims adjudication process, because you're not really, obviously you're trying to figure out what has happened and all that, but it's not really consuming with this, consumed at least with the, admissible information, and you'll use whatever information you got, whether it would be admissible or not. But at a hearing, it's got to be, again, admissible. Now, when we're prepping for hearings, and this is where, we run into trying to take all the information. So in any given case, we'll collect information too, but a lot of the information we get is from you. And so when we're dealing with the information and we're prepping for a hearing, we have to sort of parse through it all and consider what, separating the favorable information that we have that we want to adduce as evidence to advance our case versus anything that's unfavorable, that doesn't help our case. Sometimes there are some strategies where you will introduce and take on unfavorable information straight on to try to deal with it at a hearing. However, mostly when we're trying to plan our case, we're looking favorable versus unfavorable. We're also looking at reliable versus unreliable information. If you've got a witness that has no credibility whatsoever for one reason or another, how reliable is anything that they give us going to be? Obviously, when you're dealing with a hearing. The other thing, of course, is relevant versus irrelevant. If it's irrelevant, it's out. It's not going to be admitted. So we have to get rid of, or at least separate all the irrelevant documents and focus on the relevant documents, whether or not the information is available versus unavailable. So we may know something, we might be like, we have a hunch, we know for sure it's true, but there's just no information out there that we can confirm it with, versus something that it says black and white, here it is, so that's available. Or a witness may not be available in that case, obviously, for one reason or another, they've left the country. And then we're also dealing with direct versus circumstantial, and direct is like just that one piece of evidence that proves the fact. Circumstantial, of course, is you need many different pieces of evidence to put them into this puzzle to then create the final product, which is your fact. So these are all the things that we're trying to organize and assess during a hearing. And of course, many times we do feel like we're lost because it could be quite challenging. So just to give some examples of what I'm talking about here, we see this all the time. So in a file, there might be an unsigned statement. There might be a signed statement. There might be a sworn affidavit or testimony. And then of course, at the hearing, we have our hearing testimony. So this triggers what we call hearsay. And hearsay is any out of court statement offered for the truth of its contents. And when you're in court, particularly, you can't generally rely on hearsay. There is an exception if it's necessary to get the document, like the fact in for the truth, and it's otherwise reliable. And then the judge has a general discretion, when they're balancing the probative value with the prejudicial effect of that. And then the other thing is, with respect to tribunals, these kinds of documents are almost always admissible, meaning if you have a signed statement, a sworn affidavit, let's say, or an EUO evidence, and an unsigned statement, you'll generally get it in, but it's always better to have the person that wrote that statement actually provide evidence if there's any dispute as to what they wrote in terms of being true or not. So if the other side is calling a witness and that witness is going to say stuff that is contrary to the facts that are in your statement, you want to call your witness. You don't just want to rely on your statement, because the arbitrator is going to prefer usually the evidence of the person giving the testimony as opposed to something that was written by somebody before that was signed, right? So you want to make sure throughout that your witnesses are still available to you to call, which is very important. Although we do have many hearings where the parties just rely on the EUO transcripts, we don't have to call the hearings because it's not really a question of credibility. It's just a question of who said what. And that's fine. And I've also done many arbitration hearings where we just filed different statements because it's not so much of a factual or credibility issue. It has a lot more to do with the legal issue as such. The other example is when you're relying on witness testimony about something versus science. And this is very important because on the claim side of things, you may prefer the evidence of your own insured, for example, about how an accident happened or how a loss happened, or whatever the case is. But if there's any physical damage, anybody who used to watch CSI would remember that it was all about finding the physical, what science had to say. If you have physical evidence or experts testifying or at least sending reports saying it didn't happen that way, it happened this way, that's our opinion as an expert, that's how we interpret the property damage or whatever the case is. If you have that, that's going to prevail. Unless the witness comes off as a brilliant witness and the trier of fact prefers their evidence, but that's very rare because science doesn't lie typically. I think that came out of CSI as well. So you want to make sure when you're sort of assessing a claim, how this might work out at a trial as well, that science usually has the edge over just a witness statement. And then this sort of becomes credibility and reliable sources versus unreliable sources. Independent witnesses are usually a lot more reliable than somebody who has an interest in the claim as well. So a judge or arbitrator will usually prefer their evidence if it contradicts the evidence of a party, for example. So basically assessing how that might play out. And so what you want to do, and it'll make our lives a lot easier, is you want to gather information that will become evidence. So you want to investigate early, you want to secure signed witness statements from reliable sources, you want to secure important documents and so on. And you want to follow hunches, definitely, to find more information that might become evidence in a hearing. And following with that, you want to team up with your lawyers. And I say this sincerely, because ultimately we want the same outcome. And you might have tons of information, and your lawyers will be able to assist you with determining how the information that you have might be received by a trier fact at a hearing, and whether it would be admissible even, and probative versus prejudicial, and so on. Now, that was a lot to put into a half-hour session. I just want to draw attention to the upcoming Lunch and Learn webinars that are coming. June 24th, Dentistry 101, where we'll teach you how to do a root canal. And then July 20th is, watching your words and misrepresentations and so on. Now, I finished a wee bit late, and I know that there is a question in the chat. The question is my preference written statements or record? I prefer, if I'm going to a hearing, I definitely want the, I definitely want testimony over statements. If it is a statement, I want it to be signed. Signed statements are also great because they could be cross-examined on, and I'm just saying this if I'm looking at what the other side is relying on too. You can't really cross-examine somebody on an unsigned statement, because then they'd be like, no, I didn't sign that, or didn't say it. So that's sort of my thought on that. Recorded statements are great too, because a recorded statement, of course, you're hearing what the person said. So then you'd enter that as evidence, especially in a tribunal setting. You're like, look, this is what the person said. Of course, I have one file now where the person denies that that was them. So if you're going to have a recorded statement that you're relying on, you may have to have the person at least speak at the hearing, so that the trier fact could make their own determination as to whether or not that is the person who's actually speaking. I'm going to welcome anybody who has any questions about anything I said today to send me an email directly, or you could tweet me, or do whatever mode of communication you'd like. And I just want to thank everybody again for joining me for this Lunch and Learn, and I'm going to eat lunch. So have a great day, everybody.